Malm Hesse is legal practitioner. He's joining us with his perspective. Christian, I appreciate your time this evening, but when you hear the transformative assurances from the Chief Justice, you hear similar from the President. Are those the immediate needs of the judiciary?
Good evening, and thanks for having me. Yes, I believe they are very immediate needs of the judiciary. The first of it is the integrity restoration, because there's been an Afrobarometer perception index. Aside that, to indeed the judiciary has gone through a phase, and we cannot pretend that everything has been okay. And given that it is reflective in the speech of President John Dramani Mahama, and also in the speech, in the remarks of His Lordship Justice Paul Bafo-Boni, and that recognizes the fact that the judiciary has been through some turbulence, and it is believed that his chapter would restore that confidence and calm the waters, as we believe that to be.
I see. Practically speaking, what are some of the changes you'd like to see under Chief Justice Paul Bafo-Boni?
I mean, for me and for many of legal practitioners, I and more particularly talking on my own behalf, I would expect that the e-justice system will move away from just, or will expand into other regions of the country, and not necessarily be concentrated at the High Court complex. Indeed, it is interesting to note that the e-justice system, after its inception or its operational viability, has never extended even to the Supreme Court, not alone to even talk about expanding to Tema and other jurisdictions within the country, the regional jurisdictions. So it is my prayer that, as he mentioned, that technology and AI would be one of the things he'll be putting his hands on. I believe that, and I pray to say as the better, that he would advance that particular resource tool, which is also going to help in case advancement. And also I pray that he also looks at the case management system, because currently we have a lot of congestion of cases at various courts. I appear at a certain court, at a high court at Adenta, and the judge at one sitting indicated that he's undaunted with 900 cases to deal with, and he's a human being, and it would be difficult plying through all of that. Yes, there are some courts. I remember before His Lordship was promoted to, that's Justice Akabuafo was promoted to Court of Appeal. At one point in time, he was sitting at GJ6, and he mentioned that he had a caseload of about 600 cases. So, I mean, a number of practitioners will bear me out on how some of these judges are loaded with cases. And as human beings as they are, it's very difficult to see that these cases are heard expeditiously. And these are judges that they would have to deliver bench ruling in certain situations, because there are instances where lawyers want their cases expeditiously and will be putting all the rules under CI 47 in respect of expeditious trial. And, the judge is also undated with all these things. So we pray that there will be decongestion with respect to expansion of infrastructure. So, because the more lateral the infrastructure becomes, the more easy the decongestion would happen. And to speak of the lateral expansion of infrastructure, it has been my submission, throughout this process that the judiciary works closely with the district and municipal assemblies in putting out more court complexes or court houses, so that in various districts, if we have one high court, one circuit court, and one district court, it helps with the territorial jurisdiction of spreading across cases and helping with the decongestion.
Right.
And it also speeds into the case management system, so that the average length of cases will reduce drastically from 3 years to probably about a year or two. And also the enhancement of alternative dispute resolution, that's the court-connected ADR, to be made more available and be more accessible, and be drummed or through education be made available to litigants, that it is definitely an alternative system, because most litigants, when you apply for court-connected ADR, they are less desirous of embracing it.
Right. And those things that you have spoken about would deal with the speed of the wheel of justice, right? But how about the swiftness of that wheel as well? When the Chief Justice, excuse me, not swiftness, but the fairness of that wheel of justice, right? When the Chief Justice speaks about the independence of the judiciary, when the President talks about the judiciary not bending to the whims and caprices of the powerful in our society, what steps must be put in place in order to achieve that fairness that we expect of the judiciary?
I mean, both the president of the land and also the Chief Justice indicated that they need to strengthen the code of ethics for judges, and also there need to be the strengthening of internal mechanisms, so as to strengthen justice delivery and access to justice. And when these things are done, just as they opined, I also believe in the same thing, that when these internal protocols and ethics with respect to conduct of judges and all of that are strengthened, and also more training programs, which I know currently it happens more at the judicial. They have a judicial secretariat where some of this, they have their trainings, that we see more of these things happening, so that such refresher courses would always put our judges on awareness, because they are doing a lot for Mother Ghana, and we need to commend them. And so when some of these things come in there, it will enhance their resource capabilities to ensure that justice goes out to everybody, irrespective of the position or the political power that person wields.
I see, but hear me out, Hesse. How seriously can we take that when in this country we are all behaving, turning a blind eye to the fact that there's been an announcement of a petition against the now Chief Justice, a petition of his misconduct, allegedly? How seriously can we take that transparency that we talk about, that not bending to powerful people in the society or the judicial independence?
You know, if we look at Article 146, I had spoken about it more on your platform, and I sometimes try to bring in new angles. So at a point in time, some people started calling me Mr. Jurisprudence, you know, and having discussed all the issues concerning Article 146, it is very conclusive to say that that particular provision in the Constitution is problematic and is fraught with its own problems. And until we have a regulation that would support it for certainty and in terms of procedure and all of that, or until we have an amendment we are going to see some of these things come up. And this current Chief Justice will not escape such petitions. And definitely whoever has grievance, whether legitimate or not, we are going to have that go through. And it will now be for the president to determine in conjunction with the Council of State. These are some of the things that Justice Dateba in the Ajay case as Attorney General spoke against, that we would find ourselves in situations where the president would have to sift through some of these things, and given whether the president is for it or not, it will become problematic. So again, in as much as we are looking for such robust reforms, we need legal regimes also to help the process correct itself. Yes, we have checks and balance. We have checks and balance. That's okay, so that we don't have over concentration of power in one institution, and that would abuse power and all of that. But at the end of the day, too, we also need to ensure that the rigors of the law flows through, internal processes are strengthened, and by that we are going to see the best of his administration. We wish him all the best, and we pray that his chapter brings success to the judiciary and the weather is calm for it.
Hesse, that's all we have time for. Thank you so much for your insight on the subject matter. Christian Malm Hesse is a legal practitioner. We've just been discussing